Jared Grifoni, representing the Libertarian Party of Collier County, requesting that the Board of County Commissioners rescind Ordinance 2013-70, which established the La Peninsula Seawall Municipal Service Benefit Unit, and rescind Resolution 2013-292, which established a special assessment for funding the seawall improvements. Both ordinances were adopted by the Board of County Commissioners on December 10th, 2013.
Mr. Garfoni.
Morning, Commissioners. Thank you for the opportunity to speak to you regarding this creation of the MSBU for La Peninsula, a private gated community for the purpose of repairing and replacing their seawall, their existing seawall, for the benefit of the property owners in that development. I know I only have 10 minutes today, so I'm going to try and make all of this brief. There's a lot of issues here, so excuse me if I am concise. First and foremost, though, we need to touch on the Constitution. The Florida Constitution is definitive. It's the foundation for our source of government. It's the foundation for our Florida statutes and even our county ordinances. Article 7, Section 10 deals with finance and taxation. And in Section 10, it specifically states that neither the state nor the county or other entities can lend or use or give its taxing power for the credit to aid any private entity. Now, again, it cannot use the taxing power to aid any private entity. Now, we know that there are some exceptions to that particular portion of the Constitution. They deal with public trust funds, obligations backed by the United States, and so forth. Seawall repair and replacement is nowhere to be found. But is the county really using its taxing power here? Because we're talking about MSBUs. Well, MSBUs are special assessments that are paid back from the property owners within the boundaries of the created MSBU. Now, in AGO 8590, Marion County faced a similar issue. They're a non-chartered county, just like Collier County is. And in that AGO, it was written that special assessments are distinguishable from taxes, but they are levied under the taxing power. So again, we do need to fall back to that constitutional provision. We are talking about the taxing power here. Now, if we are all the constitutionalists that we say we are, that really should be the end-all and be-all of this discussion. But really, there's a lot more to go over. And some people say that the Constitution's a living document, Florida Constitution or the federal Constitution. Some people say that it's eroded over time. But the fact is, we all are here to stand up for the principles of the Constitution. Now, the Florida statutes are the same. Statute 125, or Section 125, that was the authority under which the MSBU ordinance was created. Now, in 125.01Q, that's the relevant portion. It states that MSBUs can be created, they can be utilized, but only for certain items, for things like fire protection, law enforcement, streets, sidewalks, garbage and trash collection. Again, seawall repair and replacement is nowhere to be found in that statute. There's no seawall repair or replacement there, and the statute's very specific. It deals with public utilities, in a sense, public things that are unrelated to private seawall construction. Now, 125 is the authority listed in the ordinance itself, and I've received an email from the county attorney as well, and Commissioner Hiller, we've discussed it as well, regarding Florida Statute 170. Now, 170, the email that I received from the county attorney noted it wasn't a legal brief, and I think for good reason, because 170 doesn't apply to counties at all. 170 applies to municipalities. Title 12 is for municipalities. Title 11 is for counties. So 170 doesn't apply here at all. Now, and it certainly doesn't apply for Isles of Capri, because Isles of Capri is an unincorporated area of Collier County. It's not a municipality. Collier County isn't a municipality. Municipalities are chartered cities in the state of Florida. So we can see whether it's under the Constitution or the Florida statutes, whether it's 125 or 170, the authority just doesn't exist. Well, what about the county ordinances? We can look at those too. 122-2043 of Collier County ordinances deals with MSBUs. Well, in that ordinance, it says that MSBUs can be created to provide for water, sewer, streets, and other essential facilities. Now, this piggybacks on 125. We're dealing with the same thing. Water, sewer, streets, and other essential facilities. Essential facilities are most frequently defined as natural monopolies, things like utilities, transportation facilities, things of that nature. Again, not seawalls. Essential facilities are public facilities, not private facilities. So we don't have the authority under the Constitution, the Florida statutes, or the county ordinances anywhere for repair and replacement of seawalls. Now, there's a variety of AGOs out there, and I'm not going to go into all of them today, but Flagler County, City of Belle Isle, they've done these things as well. They've tried to do these things as well, and they've all been rejected on the grounds that there's no public purpose. Now, we know that when county funds are expended, it has to be done for a public purpose. And at the December meeting, Attorney Klatzkow mentioned that at the end of the day, public money must be spent for a public purpose. So what's the public purpose? Well, AGO 9037 is actually even a little stricter. It's not just a public purpose, it's a paramount public purpose. Now, like I mentioned, Flagler County had a similar issue. City of Belle Isle tried to create an MSTU, slightly different, but same thing, it's just how they're taxed. But an MSTU to cover the costs associated with private common areas. That was rejected because there wasn't a public purpose. It was, again, the benefit of a private agency. They fell back on the Constitution, Article 7, Section 10. Same thing that we're talking about here today. Escambia County, now they're unrelated to Collier County, but they are a non-chartered county in Florida. They have a very clear and concise policy on MSBUs. Their MSBU book states, quote, "The funds raised are public funds and must be collected, accounted for, and spent in accordance with applicable laws regarding public funds. Only public property can be maintained and improved by an MSBU. Access must be open to all members of the public equally. In addition, adequate easements or property dedications must be provided." So again, what does Escambia County know that for some reason it seems like we don't know here in Collier County so far? Code enforcement as well. We've seen this. Well, what happened to code enforcement? Have they been, going to sleep for 5 or 10 years? No, actually not. Code enforcement has been called out. They have looked at the La Peninsula seawall back in 2009. They found that there were minor cracks of no concern, normal wear and tear, and the seawall wasn't in any failure. Well, 2009, that was 4 or 5 years ago now. Well, what about more recently? 2013, same thing. They went out to La Peninsula to inspect the seawall. August of 2013, just a couple months before this issue was even brought before the board. Well, County Engineer Jack McKenna, he made a determination that it's not a health and safety situation, that the seawall needs some minor repairs, that there's no violation at this time, and that a permit wasn't even required to make these repairs because they're so minor. So what exactly is going on here? Well, we know in August of 2012, La Peninsula voted down 4-3, spending $4,000 for an engineer's report for DEP, $18,000 for a building permit that would have been good for 5 years. We know that they had approximately $200,000 in seawall reserves at that time. We know that there was an ongoing legal dispute between La Peninsula and the former owners of the seawall over whether or not the seawall was turned over in proper condition. That lawsuit happened to be voluntarily dismissed in 2013. And I don't want to speculate, but again, do we really have all the facts? Now, the issue here, too, is precedent. Precedent's a big one. Precedent that's going to be set here is very dangerous. We have over 500 homeowners associations in Collier County. And if they all came looking for the same bailout, because that's what this is, it's a bailout for mismanagement, you're looking at $2 billion added to county debt. This money does get added to county debt, even though it's paid back by the MSBU. Does Collier County really want to get into that situation? Again, never happened before in the state of Florida. It's never happened before in Collier County. Now, we don't even know how it's going to be financed. It's like Nancy Pelosi came down to the Collier County board and said, well, you got to pass this ordinance to find out what's in it. We don't know what's in it. Commissioner Hiller, even at the December meeting, you asked, how is this going to be financed? Who's incurring this debt? And the answer from Attorney Klatzkow was, we don't have financing plans in place yet, and I cannot answer that question. Well, that doesn't really fill me with a lot of confidence, to be honest, and I think really it's just a lack of having the information in front of us. The ordinance itself, again, it says that, hey, if there are conflicting ordinances in existence, if there's conflicting laws, the more strict laws shall apply. So again, we see this, if you look at the whole picture, there's a lot of issues here. Now, I hope I've been able to express a lot of these issues in a clear and concise manner in the short amount of time that we had here. And I believe that the commission here is a good one, and I believe that you've all been proceeding in a manner that you believe to be best, not only for the Board of County Commissioners, but for La Peninsula, as well as Collier County residents. And I think that this new information really deserves more than 10 minutes of a rushed conversation here to really be delved into and to look at properly, just so it has the proper justice here. Now, we can argue back and forth about the condition of the seawall, whether or not this board owner said this or that board owner said that, but it's secondary to the legal and constitutional authority that simply doesn't exist. Now, in summary, the county ordinances don't support this, code enforcement doesn't support this, the AGOs don't support this, Florida statutes don't support it, and ultimately, and most importantly, the Florida Constitution doesn't support this either. Now, we have a variety of unanswered questions here. and it's incumbent upon this board to exercise the proper due diligence on this MSBU going forward. We certainly don't want to get into another situation where there's another lawsuit that is unnecessary, that doesn't need to happen. We need to review all these facts before we go forward and make sure that this is on the proper legal and constitutional authority. Now, we all are here because we believe in fiscal conservatism. We believe in the proper role of government, and I think this board wishes to continue to follow those principles, to abide by those principles, and frankly, those principles unite virtually all of us here in this room today. I believe that the only appropriate action that can be had today is that this board moves to rescind the ordinance and resolution, and it's brought back up at the next meeting. I think that this needs to be done. There's so many issues here, and it was very difficult to get them all into the 10-minute time span here without properly explaining them all. But as you can see, there's a lot to discuss here, and I think it's incumbent that we do look at this again.
We actually have time left. That's a 1-minute warning. You still have a 1 minute.
Actually, that's it.
That's it?
That's it.
What happened to our yellow button?
I don't know why we did not get a warning on that, so I'll figure that out.
Yeah, fix that. Commissioner Nance?
It's actually Commissioner
Oh,
Hiller,
Commissioner Hiller, I'm sorry.
but I'll go by
We'll
any
change
name.
that. We need to change
it's-
that.
You look
Works.
so much alike.
Yeah, I know.
Yeah. Commissioner Coyle, please.
So, first of all, Jared, you've presented very well in the 10 minutes. You brought a lot of issues forward. At this stage where you've put forward a request to have this matter brought back, I don't believe that this board has the ability to rescind the ordinance right here and now. So I don't think that can be part of any motion. But I feel that there are enough questions being raised that this should be brought back, and I think we do need to get definitive answers on everything that you have put forward, because we do want to act legally, and we do want to respect the Constitution. And so I would like to make a motion to approve your request to bring this matter back. And I don't think it should be brought back at the next meeting, because I think the county attorney should be given time to review your questions and do the appropriate level of research necessary to come back and inform us as to, in a formal legal brief, what his position is on all the legal points that you have raised. I mean, they're important questions. So I make a motion that we bring this back for a future hearing, and that it be the first hearing in February.
I'll second that motion. However, the proper form would be to write a memo to the county manager asking for reconsideration. I'm assuming that you're going to do that.
Well, is it really a reconsideration? Because it's not really a reconsideration of this. I mean, we approved it. I mean, I can, because I did vote in the majority, so I can do a request for reconsideration. But in this case, this is a petition to review legal questions related to an ordinance, and if the finding is that the law doesn't support what is being proposed, that ordinance be rescinded. So do we need a reconsideration, or can we just move forward in the following manner? Which I don't care. I'll do it whichever way.
My preference is to limit the number of issues, and I concur with the chair on this. If you would draft a letter to the county manager under the reconsideration ordinance, you are removing a potential issue.
Okay. Is that your pleasure, Commissioner Henning? Would you
Well,
prefer I do it like that way?
I'm just saying the process that we set out in our the county commissioner meeting ordinance under reconsideration, a memo should be
I
sent.
mean, a memo is not a problem. County manager, would you kindly draft a memo that I'm going to sign and send back to you? I would really appreciate it. And we could get that done today, and that way we don't fall short of what our reconsideration ordinance requires. Is that okay, County Attorney?
Thank you.
Is that okay with you, Commissioner Henning?
That's fine. Commissioner Fiala, Commissioner Coyle, and then Commissioner Nance.
Thank you. It looks like this is going to pass. So I wanted to ask the county attorney, number one, it seems like a lot of this is interpretation, and everybody interprets everything from their own point of view. So as we're doing this, we have many, many, many MSTUs, MSBUs, and so forth. And so while we're taking this into consideration, I want to know that, like for instance, forest, lakes, roadway, and drainage. We never had that before. just as we didn't have seawalls, does that then say that they cannot continue with their MSTU or MSBU, whatever it is? And what about Pelican Bay? They've taken their MSBUs out for landscaping, and that's wonderful, and they want to do that, and I support that. But again, is that interpretation? I think that when it comes back, we better find out who all can do it, or is it just La Pen that can't do it, but everybody else can? I think that needs to be decided here for us. We also have Radio Road East that's funding landscaping improvements. We also have Pine Ridge, Naples Production Park. These are all things that I think, again, we have to address. If we're going to interpret one thing one way, then we better interpret all of them that way and find out who's getting it and who is not, who's allowed to keep theirs and who is not. And also, I would like to know, the county attorney, do you have anything to add to some of this stuff?
No, I believe this was a lawful ordinance. It was lawfully enacted and falls within what the board's done in the past with this MSTUs, MSBUs.
Can you talk into your microphone?
Yeah, it's hard
I'm
to hear.
sorry.
I believe that the ordinance is lawful. It was lawfully enacted. I worked with Neighbors Giblin on this one. They're the state's leading authority in this area, because I did know that we're pushing the boundaries a bit on this one, to put it mildly. But I do believe that the board had the authority to do what it did, and if this thing's brought back, we'll fully articulate this in executive summary as requested by Commissioner Heller.
Okay, Commissioner Coyle?
Yeah, I disagree with the county attorney's advice that it has to be reconsidered. I don't think it's a reconsideration, but I won't belabor the point. This is a question of fact, and you have your interpretation, and we have ours. I think we need to have a discussion concerning that, and we have to have the proof presented. I don't think it's necessary that we go through the reconsideration of this entire process. I for one, have simply can't reconcile the refusal to let residents tax themselves to do what they want to do. I can't think of anything more democratic than that process. It doesn't create an obligation for the rest of the taxpayers. Any bonds that are to be issued concerning this are secured by a lien on the property of the people in La Peninsula, not by any other taxpayer. So I can't think of anything more democratic than allowing residents to collect additional funds from themselves to do things they want to do. So but I think those questions have to be answered, and I think it should come back for those specific issues, but not for a reconsideration of the entire ordinance. But you can do them both at the same time.
Okay, Commissioner Nance?
I agree 100% with Commissioner Coyle. I don't want to reconsider the resolution in the ordinance. I believe all we've done, and it was agreed at the time, to take the first step to allow people to start to gather facts. And indeed, we need to decide if this is legal action of the board. And I think it's the role of the county attorney to do so. So I see no reason, as Commissioner Coyle discussed, to go back and reconsider the resolution in the ordinance. I'd rather address the issues as the citizens of La Peninsula are addressing their issues and bringing their proposal forward to the board. At any time in there, if the board does not find it to be a lawful public purpose, then it's certainly not going to proceed. So I think we need to answer questions. I think a full and open discussion is in order, but I will not support a reconsideration.
And you know, from my perspective, I don't see the procedure of the reconsideration versus accepting this petition and putting these issues back on the agenda. I think is 6 of one, half a dozen of the other. And if we go back to have the discussion, and the discussion proves that the ordinance is in fact invalid, then we can make a motion to revoke the to revoke the ordinance
At that time. Yes, ma'am.
So it doesn't really matter, because really it's just the procedure, I don't think is going to make a big difference. But I will amend my motion not to make it a reconsideration and merely to accept the public petitioner's request to have this matter brought before the board and explore all the questions that have been raised in this presentation. I would like to further amend my motion by adding one more thing, and that is the primary public purpose. I think staff on the county manager's side needs to come back and tell us what is the primary public purpose of the decision that we made. And I think that has to be defined, because that is an important threshold question. There are a lot of issues that are raised by this. For example, going to the issue of seawalls not being addressed. To give you an example, our CRA, which collects ad valorem tax dollars from residents within the CRA, uses those tax dollars to repair private seawalls. We have all voted on that. So that's a question which is very different than the question here, because the question here is, can we allow for a public financing mechanism repaid through special assessments for the repair? And it's not really the repair, but it really would be the enhancement of this seawall, since, as you probably pointed out, it's not a repair, it's I guess, a height issue, or it's not high enough or something
Yeah,
like
there's
that.
a lot of issues.
Yeah,
And,
so-
it's going to need to be done in 10 or 15 years again anyway, and we'll be back in the same situation.
So again, you've got the issue of, the seawall versus the debt versus, what vehicle and so forth. There are a lot of, and what is the primary public purpose? So it is a discussion that should be had, because it touches on a whole host of issues that we need to make sure that we are acting properly on. So I'll just amend my motion, since I don't think that the majority wants it as a reconsideration, and to me, it has the same effect either way. It brings it back for the questions to be asked and answered.
Okay, so you're amending your motion contrary to what the recommendation of the county attorney said. However, you want the county attorney to come back with a legal finding.
County Attorney, do you have a problem if we don't do it as a reconsideration? I think it can be done either way. I'm not disagreeing. I'm just thinking that it can be done either way.
Your issue is that if ultimately you rescind this ordinance, you are opening up an argument from La Peninsula that you did so contrary to your reconsideration ordinance. By simply, it's sort of wearing a belt with the suspenders. By simply bringing this back and asking for reconsideration, you've removed that potential issue from the table.
That's an important consideration.
Doesn't that stop the whole process, though, sir?
No.
How can they form an advisory committee if they don't have a...
Oh, yes, that it will stop. Well, it will stop that process. But if it's ultimately your desire to rehear this thing, it's ultimately your desire to rescind this thing, by casting this in the dual purpose that was suggested earlier, you are eliminating one of the potential issues that could be raised.
I see.
I'm not saying it's a viable argument. I'm just saying it's just an issue that doesn't need to
I
be
understand. So it's not that it's. I understand your point. It's not that it is improper to do it the way I'm suggesting, or can't be done the way I'm suggesting. What you're saying is to do it by a request for a reconsideration. We are properly addressing that statute, so it can't be alleged that it wasn't brought back under, I'm sorry, that ordinance, that it wasn't brought back under that ordinance.
Correct. So,
I understand.
So it's really, you bring it back for a twofold purpose.
But the advisory board can continue until that hearing, can't it? I mean, it's not going to stop the advisory board from being formed just because we're asking for a reconsideration. It doesn't stop the process.
They want to bring it to you, and you're the ones who form the advisory board.
Mm-hmm.
It's up to
Well,
you.
the basis for a reconsideration is contemplating that it's going to be it's going to be voided, so where are we going with that?
Exactly.
But
No.
not necessarily.
It's a motion to reconsider, rehear. The motion defined what we're going to rehear, and basically it's a legal argument.
Mm-hmm.
You're going to give a written legal opinion on this.
You'll get my understanding from the discussions, I will be providing you with an expanded legal consideration, and the county manager will be providing you with the public purpose.
Well, we already did the public purpose through the ordinance. in the whereas. And it says, funding for the seawall and other waterway improvements is to benefit the property owners in such area. That's a finding, the whereas part.
I'm just, this is the discussion, Commissioner.
I know I mean, there's a lot of argument up here by the Board of Commissioners, so I think if staff wants to participate in that, that's fine. But anyways, I know it's a public petition. We can't take an action on a public petition. All we can do is give direction. Commissioner Fiala, and then I
Yes.
want to speak.
Okay, I have two things. The first thing is, as we're addressing this, again, we all agree it's interpretation. So are we just going to target La Peninsula and let everybody else out of this? Or is this going to affect all the others? Like, for instance, when Vanderbilt Beach came in and they wanted to establish one so that they could bury their lines. And we all voted on that, and we felt that they would be allowed to do that. Now, each of these things that comes forward, does this mean we're never going to accept one, or only from La Pen? I think that ought to be, because if we're just targeting one community, that's, I think that's illegal. But anyway, the second thing is, Tony Pierce, could you come up for just a moment?
No public speakers under a public petition. That's the rules, and we've always abide by those. Mr. Pierce can definitely, send correspondence to the commissioners. This is going to be reheard if this motion passed. So that would be the time that the public in general can speak on the item. Okay, I want to address some things. Commissioner Fell, you stated about these other
Coyle is also on it.
Yeah, and I said I was going to speak after you. Forest Lake MSBU, their roadways, anybody can drive on their roadways. Pelican Bay, we have a ownership within the Clam Bay system, including the stormwater,
We'll check.
and again, the general public can enjoy driving down Pelican Bay Boulevard. Radio Road East was formed as a MSTU, taxing the people in the area to make improvements on county property.
They're going to have to.
Okay, and Pine Ridge is not a gated community. The people can go down there. There's been many improvements, including street repaving, configuration, and drainage for that road. And again, the public purpose was stated in the ordinance of benefiting the residents in La Peninsula. And in fact, back in that meeting, the county attorney stated this is the first that this has ever happened, not only in the county, but in the state of Florida. So it is setting precedents, all right? And the other precedence is what happens with, one of our ordinances says about nuisance abatements and seawalls. What are we going to do for all these other citizens that county staff has gone out there due to public complaint and said, your seawall has not been, it's in disrepair, you need to fix it? Are we going to create a taxing mechanism to fix all those seawalls? Okay, that's one consideration. Besides the fact that we have so many homeowners associations in Collier County, and what are we saying to the ones that have collect assessments and done the right thing by fixing their roofs, fixing their drainage, fixing their sidewalks? Are we going to say, don't do that anymore? You can petition us as long as the majority of your residents that we can provide that funding mechanism. I mean, it's a real slippery slope if we go down here. Besides the fact, it's legal challenge. And quite frankly, we create this, we get a loan or a bond, we deposit the funds, the board approves a contract to replace this seawall. Is the clerk of the court going to pay the contractor to do that? That will delay what is the assumption that this seawall needs to be replaced contrary to some of the residents within the peninsula, because it was a residents who called in for a anonymous complaint that the HOA said the seawall needs to be replaced. And again, our own engineer says it only needs to be repaired. So it's more than a global issue about legal issues. It's an issue is how much we want to increase our debt, that we committed to lowering our debt. That is another issue you need to really consider. And with that, I'll
Could you tell
turn
me
it
how
over
it
to.
affects our debt? I don't understand that. Maybe being that we don't have to hold any money up or give them any money, how does it affect our debt?
Okay, there's a misconception that this is their money. It's not. And in fact, it says the MSBU is controlled under the governing body, the Board of Commissioners. This money will be a part of our budgeting process. It will, if we borrow money, it is the county's debt. It would be recognized throughout. If it was just a matter of loaning them money and let them fix it, we wouldn't have to involve the clerk. We wouldn't have to, the chairman wouldn't have to sign, or the vice chair in this case, if it goes through, wouldn't have to sign the loan or the bond. It's the public's money. So it's recognized, and it will, you can ask Mark Isaacson if it's going to be part of the county debt.
I think we're not allowed to hear from people, you said.
County staff has responded to public petitions in the past, but you can ask the budget director in the future, or you can ask him. He's standing right up there. It's your privilege.
Go ahead.
Commissioners, Mark Isaacson, your Director of Corporate Finance. We have debt issued for Forest Lakes. We have debt issued for the Radio Road. We have CRA debt. It's all part of our portfolio. The only thing that's not part of our portfolio is what we call conduit debt. That's debt issued through the one of the Health Facilities Authority or the Industrial Development Authority, things of those natures. What I get concerned about is simply the repayment source. What's the source of repayment? And in the bond documents or in the loan documents, is the county a backstop to the debt? And those are key issues when you start looking at these little nuances that are out there within these MSTUs. Now, every one of the MSTUs that we have, or MSBUs, the debt is secured either by referendum or not, either through the taxing authority or through the proceeds of the CRA, and the county is not a backstop to that debt, period. So that's the nuances. Is it part of our portfolio? The answer is yeah, it is. But
We have to approve that every year?
every year in your budget process, you approve not only the operating funds within the MSTUs, but if there's debt service associated with it, the debt service funds.
Could I just ask you, does that mean we're responsible for that debt?
When you say responsible, we're talking about what's the specific pledge, and is the county a backstop to that debt?
Tell me what backstop.
That means if they default, we step in and pay for it. The answer is no, we don't step in and pay for it. And that's specific in the bond covenants. We make sure that you make those decisions every time you form those MSTUs or MSBUs.
Commissioner Coyle, who's next after Commissioner Coyle?
I think then Commissioner
So,
Hanson.
so it's not county debt. And
Commissioner,
that's-
it's
that's what-
part of our debt portfolio. We report on it as part of our debt portfolio. We're asked about it in terms of our debt portfolio from Moody's and the Investor Services. So it is part of our debt portfolio.
Just like the CRA
Yeah.
purchased the land in the mini triangle,
Mhm.
right?
Yeah,
They got a bond and a bank loan,
that was a bank loan.
and there was no recourse to county or other taxpayers outside of that CRA.
It's very specific in the loan document related to
Then
what
it's
you're
very
talking about.
specific in the loan
right.
document here also. Okay, I'll get back to the point. We were discussing how we would get this issue resolved, reconsideration or something else. It's my belief, and the county attorney can comment on this, that if we have created an illegal ordinance, we have to act on it to resolve it, no matter what the reconsideration policy says.
Correct.
So in my opinion, rather than confusing a lot of issues here, we should take the first step of addressing the factual issues. Is it really a debt for other taxpayers, or is it a debt only for La Peninsula? We answer those questions and any other questions that would determine the legality of the of ordinance. And if we come to the conclusion that the ordinance is illegal, then we can schedule the hearing on the ordinance itself and to withdraw it. And I think we will have pursued the proper legal process in both meetings.
Yeah.
Well, the problem with that is, in our ordinance, you have up to 2 meetings to reconsider an item. The county attorney has opined the proper way to do that. That's what the motion is. So unless the motion maker changes it, we're going to move to Mr. Nance.
Well, wait, you've just said something that isn't true. We have an obligation to reverse an illegal ordinance at any time we find out it is illegal. You cannot impose a 2-meeting limit on doing that.
On illegality.
That's right. So the rehearing, reconsideration process is simply not relevant if we have done something illegal. It is incumbent upon us to resolve that illegality as quickly as we can, and if it falls outside of the 2-meeting specifications included in our reconsideration ordinance, then we have to act anyway.
It only becomes illegal when a judge finds it's illegal.
Or if we decide it's illegal.
Well, yeah, and we will through the reconsideration process. Commissioner Nance?
I think the more important thing here, and the only reason I'm interested in this particular issue and that I voted to allow them to come forth with a proposal, is I think there's great value in the government providing an administrative mechanism to allow citizens to self-finance projects that have tremendous cost. I think the government should be very happy when citizens come forward and say, I will pay for something. Because if citizens don't agree to pay for things, oftentimes it does fall to the government in the end. So I don't want to find a bunch of reasons back to the Constitution unless there is a clear illegality to disallow what I think is a very good mechanism, and one that quite likely in the years to come we're going to find has great utility in areas where there are infrastructure issues of great cost that do indeed benefit private groups of citizens more than the public in general. And I think our waterfront is a tremendous example of that. I think we can see that across the nation and the world. So when people come up and say, we want to pay for something, I don't want to go out of my way, if it is indeed legal for us to do that, to gin up some reason to deny them the opportunity to pay for something themselves. So, you know, I will support the reconsideration. I don't really care what the mechanism is. You know, we're going to have to judge on its legality. Let's just move ahead and determine if it's legal. Then we're going to have to decide as a board if we think it has a valid public purpose or not, and go forward. And if we don't, well, they won't have that opportunity. So I don't see any big cataclysmic risk where life's going to end as we know it, either way.
So to be clear, my motion will be for a reconsideration of what we approved, and to ask the county attorney to come back to us with, I think it needs to be more than an expanded legal consideration. I think it really should be a legal opinion. If we have to go to outside counsel to get that, we probably should. And to ask, even though it does state in the ordinance that we approved that the public purpose is the reconstruction of the seawall, for the benefit of the citizens of La Peninsula, I still would like to see that validated by county staff as in fact, as really defining what is the primary public purpose of this project. The primary
we can always
public purpose
Yeah,
of this
we
project.
can always change
Right.
the ordinance.
Right.
And instead of,
Right.
Saying it's a benefit of the community, you can say it's a benefit to all.
But again,
And maybe we can provide public access to that for fishing.
let the county manager come back and tell us what is, based on the facts as they exist, what is the primary public purpose, not the primary private purpose, but the primary public purpose of doing this. And listening to the discussion, which I think was very fruitful, I would like to add one thing to the county attorney, and that is, one thing that we do whenever we issue public debt is we have a bond validation, or essentially a debt validation hearing with the courts, and it would be informative to the board if we could find out how that process could be applied here before any debt would be issued through the county.
I've had that discussion with outside counsel previously, and it'll be part of my executive summary.
I'm sorry?
It will be part of my executive
Fantastic.
summary.
That's really great. So I've made my motion, and if I could have a second.
Yeah, you already have a second by Commissioner Nance.
Okay, thank you.
Okay? Let's, since this is reconsideration, it's going to come back. Why don't we hold any other questions or comments till later? Is that okay?
Just fast one though. I would suggest to the La Pen people, if this seawall is providing silt into the pass, you might want to investigate that as you go forward, because that is definitely a public purpose. Thank you.
All
Mr.
in
Chairman, I'm sorry.
Yes.
I don't want to belabor this, but just procedurally, for the public's edification, and I'd ask the county attorney perhaps to weigh in here, but my understanding of your reconsideration ordinance relating to non-land use and zoning matters is that it's a two-step process. So if there's an expectation that the board will make a decision at the next meeting, I'm not sure that your ordinance allows for that. Jeff, I don't.
You'd have to advertise a change in the ordinance anyway. So the discussion could center on whether or not we want this change in the ordinance, which is, in essence, should we reconsider?
What
Then-
would be the change in the ordinance?
If you want to rescind it, it needs an
No,
ordinance.
You said it has to be a change anyways within the
No,
ordinance.
I'm sorry if I said that I misspoke. What I'm saying is if it's the board's desire to rescind or to amend the ordinance, I have to advertise it. So this is going to be a two-step process if the
Right.
board wishes to go forward.
Because typically, the first step is just a decision on whether or not you want to reconsider. And then if you do, we come back at a subsequent board meeting with the actual.
Yeah, put that on the
decision.
consent. If the majority of the board wants to reconsider this.
Well, I think I'm hearing the county attorney say you can have more
Well-
discussion in this case, but
We'll
perhaps.
work this out.
Okay.
Well, can I make a suggestion? Because otherwise this is going to drag on. If you could draft that letter for me this morning, let's amend the agenda to add a vote on the reconsideration at this meeting so it can be brought forward in the time frame that we suggested and get it done.
That isn't how our ordinance.
You wanted to bring this back the first meeting of February. That means we can do the reconsideration at your next meeting on consent, and then have it brought back when you wanted it brought back.
Okay, that's fine too. That works just as readily. That's
Okay,
fine.
no further discussion. All in favor of the motion, signify by saying aye.
Aye.
Any opposed?
Aye.
Motion carries 4-1. Commissioner Coyle dissenting.